Good morning.
Good morning.
Well, it was a good morning for justice this morning. Subpoenas were allowed. We will be issuing subpoenas today and tomorrow. They are returnable later next month. And we took a major first step towards acquiring additional evidence of the innocence of Marni. I was pleased with the expected ruling of Judge Stride. I quoted Jim Zagel, Judge Zagel, as saying that the case that supported our position was Goose versus Gander, which Judge Zagel reminded me was found at 1, Mother Goose 7. What's good for the goose is good for the gander. The state has this information. We need it, and the judge ordered that we get it. Thank you, Judge Stride.
Can you explain the significance of the fingerprint evidence that you're requesting?
Sure. There's a fingerprint on the doorknob of the condominium where Ronnie Ryder lived. That fingerprint is not the fingerprint of Ms. Ryder. It is not the fingerprint of any of her known associates. It is not the fingerprint of any of the police officers or coroners, investigators who investigated the homicide. And most importantly, it is not the fingerprint of Marni Yang. But it is somebody's fingerprint. There is a national database known as AFIS, A-F-I-S. I don't recall what the initials stand for, but it's a national database of fingerprints. We want to run that fingerprint through the AFIS database and see if it gets a hit. And the judge ordered today that that fingerprint be run through AFIS, and we'll see what happens. I think the state was mistaken this morning when it said that the print that we're looking for was not suitable for AFIS comparison. I think that report refers to a different fingerprint. But we know what we're looking for, and we'll see what we find. And as I said, we're grateful to Judge Stride for doing what judges are supposed to do, and that's level the playing field and make evidence available to both sides in their search for truth and in Ms. Yang's quest for justice.
We're also interested.
Things that relate to Sean Gale, the videotape, and whether he made a deal with law enforcement?
There were two issues that we raised today with regards to Mr. Gale. One was his so-called alibi and grand jury testimony with respect to that alibi. We believe that the videotape from the barber shop where Mr. Gale was getting his haircut will help shed light on that. The second was an attempt to have the state disclose to the defense whether or not Mr. Gale received any benefits or deals. The court denied that request, but we've only just begun our inquiry into that. Those were the Gale issues that were raised this morning.
As far as the alibi regarding the videotape, there's a difference in opinion about the time that he...
Grand jury testimony by a police officer sworn and under oath in order to take Gale out of this equation and put Marni Yang in it. The testimony was that he was at the barbershop at 8:30 in the morning. That's simply not correct. I'm not saying that the officer perjured himself. I am saying he was in error. Mr. Gale himself and the barbershop people say he arrived a little after 10 o'clock in the morning. Why a police officer said he was there at 8:30 in the morning is beyond me, but it's not true. There is surveillance video from the barbershop. We're going to take a look at it, and that ought to answer the question as to when he arrived and with whom he arrived, when he left and with whom he left. And I want to know that information in our quest for the truth.
Could you talk about the medical ID bracelet and the importance of that?
Yes. The importance of it is none. It has no importance, except that it was introduced at trial by the state. Ms. Reuter, you know, was pregnant at the time of her death. This medical alert bracelet says it is a medical alert bracelet sold to and worn by some women who are pregnant, alerting to the fact that they're pregnant. It was found 18 months after the murder. It was found in a field behind a banquet hall in Arlington Heights. As you may remember, the death of Ms. Reuter happened in Deerfield. The murder was in October. This was 18 months later in March when the bracelet was located. We have photographs of the bracelet taken by the police from the location where it was found. It's found on top of leaves and grass, on top of leaves and grass, not buried, not concealed. The state would like us to believe that a bracelet lived through the fall of 2007, through the winter of 2008, through the spring of 2008, through the sun and summer of 2008, through the fall of 2008, through snow and rain and sleet, like the Postal Service. And yet, it was pristine when found in March of 2009. It's a ridiculous theory. But they introduced it to say that the murderer removed the bracelet from the body of the deceased and left it in the field after the murder. Marni Yang's DNA is not on that bracelet. Marni Yang's fingerprints are not on that bracelet. Ms. Reuter's DNA is not on that bracelet. Ms. Reuter's fingerprints are not on that bracelet. There is nothing that associates that bracelet with the deceased. Her family said to the police they never saw her wearing that bracelet. Her friends said, we didn't see that bracelet on her. When the police found the body of Ms. Reuter, she was wearing no jewelry, no rings, no bracelets, no necklace, no earring. She had been shot. She was laying in a pool of blood. And the police say that the murderer removed the bracelet from her body. And yet there are no footprints in blood. There's no evidence that any was taken from her. It is a preposterous, foolish theory, trying desperately to link Marni Yang to the crime. And with any minimal investigation, it would never hold up. Just as an aside, the Major Crimes Task Force is the same Major Crimes Task Force, the same group of investigators who told the world that Juan Rivera's shoes had the blood of his victim, only to later be discovered that the shoes they claimed belonged to Mr. Rivera were bought after the murder and had never been, and weren't even produced at the time of the murder. This is a group of investigators, and sadly, a state's attorney's office that closed blind eyes and deaf ears to justice and planted evidence in an attempt to make an impossible case a guilty case. So we are in search of evidence from the manufacturer and distributor of that bracelet as to who in this area purchased those bracelets and to where they were distributed. We'll find it and we'll uncover it. But boy, this is work that could have been done before the trial by lawyers who are testing the adversarially testing the evidence of the case. So you had a question?
While we're on the road, the phone call to the landline at
Yes.
his home is pretty significant potentially, right?
I think so. We know that there was a phone call to the landline. We know that that phone call came from a New York number. We've discovered that that New York number was a collection agency. We know that there was a conversation of 40 seconds.
48 seconds.
48 seconds. So we want to know, we want to confirm that the collection agency made the call and that a call took place. And that it was to a landline to her home in Chicago, not to a rental car, not to a rental car agency, not to a murder scene. And it is a pretty solid piece of alibi evidence. I hate the word alibi. Pretty solid piece of evidence showing that you can't be in two places at the same time. There once was a Latin American saint who had the ability to bifurcate. Miss Yang is not Latin American. God knows she's not a saint. So she does not have the ability to bifurcate.
You're not saying whether she took that call.
I'm saying she took that call,
Not her children.
Therefore, she-
not her children. And that's why we need the records. I mean, Marni has told us, I was home, I took that call. So now we need the notes of the bill collector to say, we talked to Ms. Yang and this was what the call was about.
How much of today, what happened today, and the evidence you talked about today, figures into your goal of exoneration?
We took a major step forward today towards exoneration when the judge ordered the subpoenas to be issued. It is a major step because it allows us to accumulate additional heretofore undisclosed evidence pointing to Marni Yang's actual innocence. I've said this so many times in my life as a lawyer, I'll repeat it once more. The law loves finality more than it loves justice. It loves cases to be closed. For these prosecutors, this case is done. How many times have we heard from prosecutors, a jury of her peers found her guilty, a trial court sentenced her, an appellate court affirmed the sentence, the Supreme Court has denied review. This case is over. And how many times after each one of those statements have we come to court and found that justice was not done, and that the person for whom a jury convicted, for whom a judge sentenced, for whom appellate review failed, was actually innocent? This is another one of those cases. And today was another long and difficult step in the direction of innocence.
Can we ask a question or two of Mr. Marni's father?
Could I stop you?
No.
Come on.
What did you feel like today? I mean, you just heard your attorney say that this is a major step and he's feeling good.
I can't wait to report back.
Larry, stand in front of the
Can't
microphones.
wait to report the results of today to Marni. Because again, hope is what people in her situation have. And it's very hopeful. And the fact that the judge allowed the subpoenas to go forward today will help unearth what's been going on. And it's really the job of law enforcement to protect the taxpayers, the voters, and the citizens, and not to protect murderers and killers and people and criminals. So these gentlemen are in a position where they're actually doing the work that should have been done in the first place, professionally investigating the crime properly, not withholding the evidence from ourselves, the defense, and also even the victim's family. What we found in the last hearing they've actually withheld from the victim's family as far as what really happened in this crime is sinful. It really is.
Had she ever told you about this phone call? Because that is, of everything that we heard today, that's something that seems pretty clear. You can't be in two places at once. Had she ever told you that she had been on the phone about the fiscal collection agency?
She did relate to me after, in the records, was the phone call. There's the Justice Review folks went through, they found the evidence of the call and so on, and I guess the state had that evidence at hand all the time, but when they did it and they checked with the company and so on and so forth, and I had, the timing I had asked, and Marni said, oh yeah, she said, I remember that they called me very early that morning, and I had a conversation with them about, why are they calling me 8:30 or what 9 in the morning, because the law says that a collection agency is supposed to call within certain hours or something like that. So she related to me that she knew about the call.
Folks, thank you very much.
Thanks, folks.
Thank you.
Thank you.